board meetings by acknowledging that New Paltz is on the ancestral land of the Munsee, Esopus, and Lenape people. Do we have any village board announcements to make?
No.
Can everyone who isn't speaking, please mute yourselves?
Sorry, I'm having trouble finding where the meeting went in my tabs.
Tim, I hear you very faintly. Tim, you're muted.
Can you hear me now? Is that a little bit better?
I can hear you, but it's not
I've
loud.
been messing. This is a new laptop. I don't understand why the mic isn't great. I've did a Google search to figure it out today. So I'm doing the best I can.
I can hear you fine, Tim.
Okay. I'll try to speak loudly. Okay, so we moved the consent agenda. Does anyone on the village board have any announcements since we're in a public session?
I guess I will reiterate that the town is looking for volunteers who want to serve on the police commission. And anybody interested should email assistant@townofnewpaltz.org.
When do they hope to have responses by?
I don't have a clear date on that yet.
Okay. Okay, I motion that we move the resolution for bills and claims.
Second,
All in favor?
aye.
Aye. Any opposed? And then tonight, we're gonna move on to our second business agenda item. We're gonna have a workshop session. So these are workshops that are on our calendar automatically, and periodically we use these meeting times that have been set aside in advance. We thought it would make some sense to have dedicated time to, speak as a board in more detail without the pressure of a whole lot of other agenda items about the proposed good cause law. And, let's see how it goes. Maybe we'll start with the village board going around the room talking about items, and then we can make it more of a public workshop. But I think this primarily should be a village board discussion, and we'll kind of read the room and see if it feels right on this Zoom call to do it as more of a public conversation. But I'd like the flexibility to figure it out as we go. Would anyone like to start us off?
Yeah, I mean, or at least some focusing things, from notes from our last meeting. One thing that we said we wanted to revisit was getting on the same page about simply the name of the bill. We don't have to do that first, but that was on our to-do list. Another part that I wanted to make sure we discuss tonight is that first section that applies specifically to the rental registry amendments. I was going to suggest we just remove that section altogether and address those issues in a future bill some other time. And that we can discuss all that at some point too. And then another loose thread was for 129-19, the lease renewal procedure, determining the tenant's acceptance or refusal that must be provided in writing no less than And then if we wanted it 45, or did we want it 60 days prior to lease termination, just determining which of those timeframes for response we wanted. Other than that, going through, I guess, the various track changes, I made my own version of it in which I accepted the track changes, and it looks pretty good to me if we do accept those changes, if we make sure we address the things that were kind of wishy-washy, and I think remove that whole first section about the rental registry law. Also, sorry, I'm a little under the weather, so if you can't hear me, just yell.
I can hear you fine.
Good.
Michelle Arstana.
Yeah. Thanks, Alex, for addressing the things that we talked about last week. I have a ton of notes, but there were 3 things that stuck out to me of what I feel is so important and the purpose of what we're doing. And those, I'm just going to share those 3 things that I think, and there may be more, but these were just the 3 that came to mind, especially after hearing a lot of the testimony from different tenants. And I want to believe that all of the landlords and all of the tenants share this, because I do feel there's a lot of heart here. And so it's protecting tenants from exorbitant rent increases is one of the purposes. Another important purpose is to retain residents, to make sure we don't lose people moving away because of different reasons when we want them to stay within our community. And the third reason is just, to keep people housed and to make sure that, there isn't a culture in which people are being pushed out for reasons that are not just. So, I think those are just the big things for me that I'm looking at in all of this.
Stana.
I'm kind of on the same page as Michelle here, pretty much. That's I think she said it well.
Okay. Bill said that he anticipates joining us this evening, but most likely that will happen a little bit later. I think Alex's suggestion to pull out the reference to the rental registry makes sense. I think that, has been something on our to-do list for some time. We should strengthen items within that rental registry law. So I think maybe doing that separately makes a great deal of sense. Because that's an important law, on its own, and it deserves its own attention. So I think that makes sense to do that separately. I've spent a great deal of time looking at this draft and looking at the City of Albany's law, and also really trying to listen to the public comments that we've received from individuals who feel strongly about this law. And when I peel back as many layers as possible, I wholeheartedly believe that it's really valuable, because what we're trying to do is to make sure that people are not pushed out of their homes when it seems like there's a macro shift like what we're facing currently, where there's a great deal of interest in housing in our region, and people who have been here for a long time could be facing situations where they're getting squeezed out because landlords see opportunity, and they may be willing to forfeit having a good tenant in exchange for rolling the dice on a tenant who may be willing to pay more for rent. And so along the same lines of what Alex has suggested in terms of, well, let's drill down and focus on, the important aspects of this good cause law. We don't need to do the rental registry thing today. I think really focusing on um, protecting existing renters from unconscionable rent increases makes a great deal of sense. You know, that I think um, would be very valuable. You know, when I look at the FAQ for the City of Albany's law, where they say this is not rent control, um, I I believe that this is almost a backdoor way to protect tenants from rent increases, and I'm very comfortable with that idea. I think that is what we should be doing. Um, you know, it is not rent control because that's a, you know, there's a way to end up with a rent control process upstate New York, outside of New York City. And, you know, I know the city of Kingston has tried to pursue something and it has not been successful. But I think we desperately need to figure out a way to come up with something that protects tenants from significant rent increases. So, you know, I wanted to brainstorm further about this idea of like, could we drill down on this idea of unconscionable rent increases and then provide tenants with a process to respond to those, and then, you know, make it the responsibility of the landlord to defend, you know, if they believe that their rent increase is worthy and fair, then there would be a process which would involve the local courts. And you know, a lot of this writing of law stuff is way above my pay grade, but at this point I have a fair amount of experience doing it, writing zoning and writing local code. And, you know, everything I do, I vet with our attorneys, and I'm a big proponent of making things simple and accessible because I like the idea of having legislation like this that empowers tenants and then actually, you know, helps landlords understand the process too. So, you know, they can't make incorrect assumptions about, you know, how the process should work. So I like the idea of taking a step back and not necessarily using the language that corporate counsel at the City of Albany used. You know, my understanding is that there's a great deal of discussion across New York State, and you know, that law, you know, is untested, and that's the challenge with laws like this, where, you know, you run the risk of being threatened with litigation, and I feel like a law that is as simple and as airtight as possible might serve us better than something that has a lot of what ifs connected to it. And, you know, I feel nervous about you know, the law as it's currently written, because it's it's an untested concept in New York State. And I don't know, that's just kind of where my head is at right now. I think we should try to move forward on something that provides renters with protection sooner, but we also need to be prudent and not put our village in a situation where we're spending money on litigation that has not been tested statewide.
Yeah, so I hear that definitely. And second those concerns for sure, which is why, you know, after so much listening and so much talking and so much research and, you know, so much also just like following the issue, you know, from before it even became, you know, something that I had, you know, propositioned for us, have made so many changes, you know, to it to really like condense it down, for sure, you know, and I think taking out that whole rental registry part really works, and taking out, the paragraph we took out last meeting really works. And if you wanted to go in and kind of clarify more about the unconscionable rent increase part, we could do that for sure. But I think we took out a lot of the room for what ifs. And it looks like people are trying to get into the waiting room, by the way. I think we took out a lot of the what ifs, in really tightening up the grounds for good cause, for a non-renewal. I think maybe the only loose threads, besides like all agreeing on a name of the bill, determining our ideal time frame for the response from a tenant, if we want it 45 or 60 days, and then if we want to really go in and like create like a process for the determination of unconscionable rent increases, kind of like how the City of Hudson's version of the law actually has like a little process in there, kind of like what you shared with us earlier today, Tim. Very, very similar, actually. It's like the burden of the proof shall be, the court shall consider a bunch of these factors, just creating a real process there. They have that stuck in that section, and I think that could help too with more of a roadmap. But getting back to the impetus of this, it's not just the rent increases, it's the never getting a chance to renew a lease. It's getting back to my roommates from a few weeks before the pandemic began, and how they were unhoused for the duration of the pandemic because we only got our 30 days notice that we were not being renewed for no good cause. It was the only time, by the way, that I was non-renewed for no good cause. But yeah. So did we want to like add this like little process in there about determining of unconscionable rent increase, like the review process, or did we want to create that as a separate law?
Well, I feel like it works as a separate law.
Yeah, I think so too.
Because it's how one responds to a landlord who is saying, yes, I want you to stay. However, the rent is now this much more. And, rent increases make sense because expenses go up, taxes go up. Maybe a landlord's doing a capital project, but egregious rent increases, or maybe situations where a landlord is, under the impression that they could receive a lot more money because the market has changed. I would like to figure out a way to protect tenants from situations like that. I think
Cool.
that kind of unnecessary, or that type of turnover, I think is challenging for a community. Like we talk all the time about like, well, why do we like our short-term rental law? Like we don't want to allow our housing stock to turn into short-term rentals because we need humans to live here, whether they're renters or property owners. Like we need them to volunteer on the planning board, the ZBA, or be volunteer firefighters or run the library fair. Like we need permanent residents. And I feel like we need tenants to feel like they're not at risk of being pushed out of their homes when a landlord is overly motivated by earning more money. And I believe that many landlords, they're looking at the process of being a landlord holistically, and we've heard from many landlords about the value of keeping tenants. Like it's expensive and a hassle to find new tenants, to clean out the place and prepare for the new tenant. Like, landlords, have told us time and time again that their first choice is, if they have a solid tenant, keep the solid tenant, not create a new situation where they have to, prepare the house or, market the property. But
Sweet.
But I do think that the that greed will or you know, the belief that you could earn more money sometimes might outweigh the expense of flipping the house. And I think if there was ever a period, it's kind of this period now, where there's so much interest in people moving up here.
Cool.
But,
So I kind of like how I just like, sorry, I like love how we're like parsing out all these different issues, like as a community. Just had to just pause right there because like, yeah, I guess we're seeing like all these like examples of how like actually like another teeny tiny law is needed, you know, for to address these different what ifs that have come up, you know, thanks to like the original beast of a good cause law that I proposed that now is narrowed down back down to like an 8-page, pretty tight, you know, just lays out the examples of what constitutes good cause. And then so, you know, once everyone's good with like where that is, then we have like the next round of things to do this autumn, you know, so the addressing the rent increase situation and a process for determining unconscionability. Like I think we have a good take on where to, you know, introduce a bill about that. I think like we're pretty much in a good spot about that. And then I think I'll need a little bit more time to do the rental registry questions and stuff. You know, but that'll be like the next little bit, you know. So I don't know. I'm really liking how I'm seeing all these processes kind of unfold from this good cause discussion. Should we address the good cause stuff first or?
yeah, let's do that. But I just want
Okay.
to make sure we're rotating through and make sure that Stana or Michelle, do you guys want to chime in on anything that Alex and I have been rambling on about?
I guess just some clarity. So Tim, the idea you proposed, with the unconscionable rent increase law. So that is, I guess I misunderstood and thought that this was replacing the good cause that we had on the table. Are we talking about both? Can you?
No, so, well, first of all, I never even heard of the word unconscionable until Alex explained to me what it was when we were looking at early drafts of this. So like a lot of this stuff, you know, I've learned along the way. And to her point, like Hudson has a law and they, you know, use some of these parameters. And when I was, you know, trying to understand it better and research it, like, you know, a lot of the verbiage that's in that draft that I circulated, you know, is just taken from case law in New Jersey. You know, I think that, you know, as Alex has pointed out, the best way to do much of this stuff is to not invent wheels, but to, you know, look at what has already been done and, you know, identify things that have already been tested. So, right, that, and I was really responding, I think, to our last meeting where both Alex and then several of our public comments were addressing like, you know, this is basically like an arrow in the quiver of tenants. Like, how do you how could we empower tenants who are facing outsized increases to their rent? And it seems like this would be, you know, a tool that they could use. The good cause law is about rental renewals. Like you know, a tenant who follows leases, you know, has the right of first refusal, provided there is not good cause for the landlord to not renew. Like that's a separate and important concept. You know, I think having that as its own thing kind of helps me wrap my head around much of what we're trying to accomplish. What do you think, Stona?
Once I recognized that you meant it to be in addition to, that cleared it up for me, because when you first sent it around, I sent an email saying like, response saying like, is this to switch up, to change it to this, or is this in addition to? So I think this new proposal, I like it. It's very clear. It's succinct. It gets right to the heart of what we need for that. I'm not sure where else I want to go right now.
Donna, I was confused as well. So I thought it was, I mistakenly obviously thought that this draft that Tim circulated was instead of what we had been talking about. So I'm
No,
just,
it was not really instead of, it was more inspired by. So it was really like taking a concept that we were wrestling with that's in the cause law, pulling it out, tightening it up, making it more concise. That's, you know, and for, you know, for people, you know, following along at home, I mean, we should probably, you know, explain what it is. I mean, it's basically.
I was about to say something about that because I don't think anybody has seen it, and this will be noticed differently and is separate. So, I mean, it's related, but.
Can I read it?
Yeah, yes.
So, so basically, and I love this again, because like, this is like what I was like dreaming of, by the way, for this good cause law. I put too much in it to start with, you know, I will totally admit that. We've pulled out the stuff that doesn't need to be in it. And Tim found a way to, in our next endeavor, to really tackle a lot of the what ifs surrounding like the unconscionable rent increase issue. So this is like, it's a 1-page law, which is beautiful. If a tenant believes a rent increase is unconscionable and subsequently provides a written statement to the landlord detailing the reasons why they believe that the rent increase is unconscionable, upon obtaining written confirmation of the landlord's receipt of such notice, the tenant may withhold payment of the difference between the prior rent rate and the increased rent rate. In the event that the tenant elects to withhold the difference between the prior rent and increased rent, the landlord may file a summary proceeding against the tenant in accordance with the procedures set forth in Real Property Actions and Proceedings Law, Article 7. The court shall determine if the rent increase is unconscionable. Burden of proof shall be on the tenant to demonstrate the proposed rent increase is unconscionable. The court shall consider factors to determine the unconscionability of a rent increase, including 1, whether the increase is greater than 4%, or does the increase represent a pattern, including previous rent increases that collectively may be unconscionable. 2, the landlord's expenses associated with the operation of the subject property. 3, capital improvements. 4, how the existing and proposed rents compare to rents charged in similar rental properties in the area. And 5, whether the rent increase would shock the conscience of a reasonable person. And I think that's just a good like first stab at like, for something that makes me feel so much more comfortable with, in terms of the good cause law, like really sticking to the basics of like, you know, laying out what are the examples of good causes for a non-renewal, you know, really sticking to the basics of that law, and then further parsing out some of the issues that like we've, you know, seen like really speak to the heart of our community, like as important issues, like in further laws as our next steps, right? Rather than trying to tackle it all in one thing, you know, really start, we're seeing the things that people are yearning for more process clarity on as a community, like in this whole process. And it doesn't have to all be done in like the good cause law, that doesn't make sense. But parsing it out on each different step, I think makes sense. And I think Tim's inspired law idea from earlier today is a good example of that.
So while I like it and everything, I just don't want us to spend too much time tonight on that, since we're here to work on what, you know, we're here to work on that's already on the table, because that hasn't been, you know, proposed or anything yet.
Well, I think it provides important context, though. That's why I think it's worth having a conversation about it.
Sure, but you know, we've been spending a lot of time working on good cause, and that's, you know, like specifically what we were here tonight to work on, and I'm concerned about time and
Okay.
there's just a lot to discuss about in the
Right,
original law, so.
So Stana, where do you want to take good cause? What would you like to address?
Well, you know, we had a big sticking point at our last meeting, and I'm not clear how we want to resolve that, or if, you know,
Which
when we were
sticking point
talking,
is that?
when we were talking about, where's my brain? I'm sorry, I'm drawing a blank. I've been, I had a pretty bad insomnia, so my brain is a little foggy. I'm sorry.
Was it the
Okay.
rental
Michelle, can you help in
registry
with-
part?
Yeah, the rental registry part, that's where we were spending some time. We were talking about building A versus building B, like let's say building A.
Right, right.
So
That's what I was talking about.
so
Yes,
I
yes,
suggest
yes.
we just take that whole bit out completely. That's my suggestion. And I struck it in our, you know, working draft that the public has access to and should see that suggested strike. I can unstrike it though also. It's just a suggestion. But yeah, just removing that completely is my suggestion. I think that would be best.
Okay,
Alex-
because you were very, very particular about wanting to keep it in, so I'm just,
I think it would be best if we remove it.
I'm fine with that.
Alex was probably particular about keeping it in general because she wants to address that issue.
I'll do it next.
I
It's
think
sim-
what she's saying is that that issue can be addressed.
Right, I see. Yes,
Separate.
no, I'm fully for just taking it out.
And if I could offer a little bit more insight as to what I was thinking about as I was driving out to Ohio to register voters in the middle of the night after that meeting, I was just thinking about how in general, ever since I was, you know, deputy clerk, started in 2016, and when the Landlord Tenant Relations Council did have someone clerking meetings, that was me. And like since then we've seen the way like the building department and the way the clerk's office and everything, all the technology has changed over the years. The way things are filed is changing. We're seeing some different changes in how to make the rental registry even more accessible and automatic and all this stuff. So I think honestly, anything to do with our rental registry, I want to the more I thought about it, I want to just give the rental registry changes that are happening, like due to tech changes in the way the village operates. I want to see those tech changes happen first and make my suggested changes based a little bit more upon the reality of like exactly what jot forms will do, for example, for our building department and whatnot, if that makes sense. So to give you a little bit more background with why I'm comfortable parsing those issues out and it's a separate law. I'd rather just kind of see how it plays out with the way tech works. And
So
record keeping.
I like this. I'm great about, I love streamlining. I think that's ideal.
I have a question. I think I have a copy prior to the one perhaps you struck out, Alex. So I just have a hard copy. So
Oh,
I just want to make sure so 12915 evictions is what's being struck, correct?
so it's 12914 collection of rents, 12915 evictions. And also in summary, it will be from amending to further. And so the summary will be a local law adding a new article to Chapter 129 of the New Paltz Code prohibiting evictions without good cause. And we could wordsmith that according to whatever name of the bill you all want.
Thank you.
Correct. Yeah, you're welcome. And then so effective date below 14 and 15 also would be stricken. Because that effective date was in reference to those amendments.
Okay, so then why don't we go ahead and talk in more detail about what continues to exist in the draft for the good cause law.
So just to again, focus the two other things that you all want to discuss, the name of the bill, and then the determining the time frame for a tenant response in 129-19. Like the name of the bill. And then once we determine the name of the bill, that means I could do some updating in various parts that seem a little messy, you know. I like having it clear that it's like prohibition of eviction without good cause, and that it's a rental renewal law somehow in one sentence, however you all wanted.
Yeah, I'm a whole lot less concerned about what the name of the bill is.
Okay, I know. I just know it was important to the rest of the board.
Tim, I'm sorry to jump in. I don't know if I'm allowed. Can I make a suggestion?
Yeah,
Or
go
is
ahead.
that not how this is done?
You can go ahead, Matt, sure.
I was just gonna say, I think what it really is a good cause non-renewal law.
Can whoever's speaking please introduce themselves because it's not clear who you are.
I'm sorry, it's Matt Eiler. How are you? Stan?
Hey, Matt.
I was saying that I think what this really is it's a good cause non-renewal law, right? You need to have good cause to not renew. Or is that too cumbersome? I don't know. That's just what I just think we should call it what it is.
Matt, that kind of was the point I made last time, because I felt it was first good cause eviction and then it was good cause rental renewal, and it changed the scope of like, it just changed the scope of it. And so if we said non-renewal, that keeps the scope of eviction without the word of eviction, which I guess some of us felt maybe wasn't a good word to use.
Well, right, because I mean, at least as of now, the way the law is, eviction is a different thing. It's a legal proceeding to remove someone versus what I believe this law is trying to do, which is protect people against an unreasonable non-renewal, which has been called in earlier drafts a de facto eviction. But I do think it's a little of a loaded term, and it's not really an eviction. It's a non-renewal. So I think that what you want it to be is it's a good cause non-renewal law. If a landlord doesn't want to renew their tenant, they need to have good cause to do so. I think that's what the law is about.
Makes sense to me.
I think that, I mean, Michelle, what do you think?
Yeah, I prefer good cause eviction or good cause non-renewal. That it's the scope of it is the same and just changes. I would be in favor of that. Yeah.
Okay. Just for context, since we discussed it, I included the link to the draft of what we're tentatively calling the Village of New Paltz unconscionable rent increase law. It is now in the agenda where we're discussing this, items related to this workshop.
But
Thank
of course,
you.
there will be time in the future to like specifically discuss that law as well.
That's why I put draft in all caps.
Yeah, but what we're discussing now is a draft as well. So
Yeah, they're all drafts. So I think the other challenge and what I like a great deal about the spirit of the good cause non-renewal law is this idea that, you know, the tenant should have a right of first refusal to stay, and a landlord could ask them to leave, but only if there's good cause. I think what's interesting, and the feedback that we've received from numerous property owners and landlords, and we've tried to address this in our draft, is how do you create boundaries or guidelines for this process? Because I think that's where, you know, legislation can be helpful and legislation can make things cumbersome. So, you know, many rental situations, if someone wants to stay or go, or a landlord's looking for a different situation, you know, they're going to start addressing that 3 to 4 months out. And I think we included this idea that the landlord would approach a tenant that they would prefer to stay 3 months out. And then, you know, it's very reasonable for the landlord to not hear back from the tenant immediately. You know, it might take a few days, a few weeks, whatever. You know, that kind of decision takes a little bit of time, even if it is a renting situation where you like where you are, the landlord wants you to stay on the property. You know, it's not necessarily an easy, like, oh, absolutely, I'm staying. So we tried to, you know, create a certain amount of time, and we banged around this idea of like, well, then you have to let the landlord know 60 days before the lease ends, or 30 days before the lease ends, or 45 days before the lease ends.
We were stuck between 45 or 60.
Right. I was just, you know, providing just general
Okay.
context, reminding all of us.
129-19, by the way, to read along.
Okay. So I think what's unique, and I mean, it's hard creating guidelines or boundaries or legislation for business transactions that, like, no two are the same. You know, lots of people approach things differently. Some people, you know, do their holiday shopping in August, and some people wait until, you know, the day before. And I feel like it's similar in situations like this, where, you know, we live in a college community, and what's interesting about our rental market is, you know, it's fairly transient. You know, there are people who are staying in off-campus housing for 1 year, 2 years, maybe 3 years, but it's, you know, there's a lot of turnover. And there are landlords who specialize in serving those college students. And I know that the college likes to know, you know, how many bodies are they going to have in the dorms before Christmas. I believe it's on their website. They want to know, you know, obviously that, you know, if they have rooms, they're going to let you in at the 11th hour. But they, you know, for planning purposes, they probably provide a deadline that's before Christmas. And I think the rental market for college housing in our community functions similarly. And a lot of the landlords, you know, they want to start figuring out, you know, who's staying, who's going in the fall, you know, basically almost a year ahead of time, 9 months ahead of time. So, you know, our whole conversation about, you know, we want you to stay, we're giving you notice 90 days beforehand, and you got to let us know 60 or 45 days. Like, none of that feels applicable in a college rental situation. And my concern with that is, well, what is this law really doing in that situation? Are we really adding value? Are we really protecting anyone, whether it's a landlord who specializes in renting to college students or a college student? So that's kind of like, you know, I think that the challenge that we have as we have a draft law where we were trying to, you know, create guidelines that I feel like make a decent amount of sense in a different marketplace, but might not make sense for college rentals.
Well, yeah, I mean, for some more context on this section, originally, it wasn't in my original draft of it, because I was thinking about just all the different kinds of scenarios. And then that's why it made sense to kind of go at it, because it is important, you know, and a lot of folks spoke out in the first couple of public hearings about how like there needs to be like guidelines for the actual renewal like timeline, right? And I can so appreciate that, like that's so legit. So that's where going with like bare minimums based on the termination is a way to go, because that doesn't disable the more of a college type scenario that plans way more ahead. Like that allows for, you know, them to start their process, you know, 5 months in advance, you know, and whatnot. But I don't know. It's hard to make a one size fits all, which is why I didn't have this in the original version, you know. Like, yeah, there definitely should be, you know, some sort of bare minimum requirement, I think, you know, in terms of when you're letting people know the positive end of it, even though again, the law more so is intended to lay out what are just the good causes for a non-renewal scenario rather than, you know, how do you carry on with renewals. But, you know, so that's why going with the bare minimum requirements in terms of, you know, and using the lease termination date as the timeline makes the most sense to be the most inclusive, because it does allow for the more planning in advance scenarios. You know, this was added because you all wanted it. What was that?
Can I jump in with a suggestion?
It's up to Tim.
Who are you?
It's up to Tim.
Adele Ruger. Hi. It's
Hey, Adele.
Ruger. Hey, how are you? You know, I spoke to the not residential life, the student affairs. What, as it's written right now, oh, you're asking me to start my video. Okay. As it's written right now, the students will be scrambling for housing during their finals. If you're taught, because most of the rentals, I'm not saying everyone, most of the rentals start in June. And if they have to let you know 45 days in advance, then you're talking April 15th. It's a terrible time. So I was wondering if you could attach it not to the lease end, but attach it to the notice. So let's say a landlord starts in December, you know, pick a month, December, and he asks his tenants if they want to stay. Because people are calling landlords for rent. So then the tenant can get 45 days to respond to the landlord, rather than attaching it to the end of the lease, because it will be a disaster for transfer students, won't be able to find housing. I mean, if they wait all the way till April to locate housing, it's going to be terrible. It's going to be a mess.
Okay, but what about tenants who aren't students? And, you know, normally it's, you know, there is no noticing that they have to give. They can let them know about, you know, in the last month.
Well, no, that's not usually true. Nobody lets people know at the last month. What I'm saying is, once your landlord asks you, you have whatever days, whatever number of days you guys decide, you know, 30 days or 45 days to let the landlord know if you intend to stay. Putting it to the end, and I don't know, I know that there's 70% rentals, but what percentage of that is students? Huge. I mean, it's a huge. And you'll be turning away people that want to transfer into the school because they're not going to wait until May to decide. Anyway, that's
No, but it's easy, this is Matt Eiler again, just piggybacking on that, it's easy to address both questions at once.
Yeah.
Leave it in as no less than 90 days that you have to give, notice to renew. So that gives every normal person plenty of time. And then make it, as Adele just suggested, they have to let you know 45 days or whatever it is, 30 days, 45 days, I don't care, after that notice is given. But the no less than 90 days doesn't prohibit a landlord who's as Tim was pointing out, it's a very different business model. If they want to give a notice of sort of asking if a tenant wants to renew or not, all the way back in October or November, then the tenant still has time to think about what they want to do. But if they don't want to renew, because perhaps they're graduating or perhaps they have other plans, it gives the college rental landlords time to go find another tenant. And that is in the best interest of our student population, because none of them want to be left not knowing where they're going to live. I mean, if they can't find a rental, maybe they do live in the dorms or whatever.
My concern is that if a landlord is sending notice 5 months in advance, that, I mean, I guess if it's 90 days, then that's reasonable, but.
The big issue here is, I think.
Well, well,
this is
hang
Roger's
on
fault.
1 second. I wanted to point of information for Stana. So in many cases, New York State law will require 30, 60, or 90 days notice. So that's why we couldn't make it any less than 90 days because, and it depends on so many different scenarios, but it depends on your length of time, at a residence. Even if your lease, like, what was one weird scenario I read about? It was like a lease that like they took over a lease and then they had a lease. So it's like not like they were even there for many years. It was like a year and a month, but they were there for entitled to like the next tier of time. So 90 is like, kind of, we can't have it
Right,
less
but we
than
were
that,
saying
right?
60 or 45 in the other direction, so I'm trying
Right.
to.
Yeah,
Right.
so that's not something that state law, has in place. That's where we're kind of filling in. That's where we have our home rule. Part of me is like super amenable to this idea of like, instead writing it like the renewal notice provided for in the section must include plain language affirmatively advising the tenant of their right to renew their tenancy. The tenant's acceptance or refusal must be provided in writing no more than 45 calendar days from confirmable receipt of written notice regarding opportunity to renew. Like, part of me feels like super like okay with that, but then part of me also does worry if it is 5 months in advance and they haven't yet, finished. Like, for example, I didn't know when my graduation date was going to be in grad school until I finished like a couple certain things, like requirements. Like, that's just how it is in like grad school at SUNY New Paltz, I guess. And then I wound up graduating suddenly. You know what I mean? Like, you don't know until you know if you finished like your placement requirements or not. You don't know what your financial aid looks like that far in advance, and so on. So that's kind of why I was a little concerned about tying it to that, even though I do understand, but that's where maybe going 90 days prior to lease termination would better help those landlords in those scenarios. It doesn't give you the full 5 months, but it does give you 3 months that you don't currently have.
What I was going to say was, we're trying,
Wait.
this is Roger's school, we're trying to make.
Wait. We recognize, we don't know
You
who's speaking.
gotta, if someone wants to talk, you gotta let us know who it is, just for.
Yeah, I've had my hand up on unmuted. This is Roger's school. We're trying to make one size fits all here. And I'm not in disagreement that people, 1 second, that people are not in need of protection. But I think, what the needs are for the students and what the needs are for the long-term tenants who are part of our community are just very different. And you're trying to squeeze them all into one law. And I think what we're looking at here is two separate laws. Because what you have to put in place is so completely different. The needs of the students and what ends a student's tenancy is very different than what ends the tenancy of somebody who's living in our community and needs to be protected. They're not the same kinds of protections. And you're trying and you're struggling with trying to make this one thing fit everybody's needs, and it's not going to. And I
Well,
think that's where most of the kickback is that you're getting from the landlords.
And the reason
is
that we're
to let-
struggling is because there's no way that we can make a distinction between students and someone else. That would not be legal.
Yeah, we can't because so source of income is in fact now since 2019 a protected class in terms of housing. And so there's
Not true.
some
Source of
is.
income is not the same as occupation. So in New York City, there's a law that you cannot discriminate for occupation. But outside of source of income means if someone makes their living through Social Security or social services or has money in the bank, you cannot discriminate against that. But you
Right.
can decide, for example, that you don't want someone of a certain profession as your tenant. It's still legal in upstate New York. It's not legal in New York City. So I just want to, I heard you say that before, and I'm happy for you to check on that. But I'm a realtor. I've asked a couple of realtors. My understanding is that occupation and source of income are not the same thing. Okay. that's
Oh,
it.
thank you, Adele.
I'm pretty
I'm
sure.
gonna-
I'm not a lawyer, but I am a realtor, and that's my understanding. So
Let's
That's helpful.
yeah, that actually helps me a lot. I might ask you for some help on that later on, actually. Thank you.
I do agree that there's an issue here of one size fits all being, unattainable. So I don't know.
This is just Matt again, Matt Eiler. I do think that that's an interesting thing to think about. I agree that a lot of the pushback that I've been hearing from landlords, now me myself, I'm not a big landlord. I only have a building or two and I don't have college rentals, but that's neither here nor there. What I'm saying is a lot of the concern is that this law doesn't fit the business model of the college rental. And if you listen to what Tim said at the beginning of this, and this isn't to say that we, of course, do have college students that are participants in our community, but I think we should think about the fact that the college rental market and those tenants are almost inherently transient, that they might be here a year, they might be 2 or even 3 years, like Tim was just saying. But this question, it sounds like the really deeper reason you're pursuing this law in the first place is to make sure our community members, the people who have roots here or have lived here for a while, who are volunteering for the boards, who are part of what our village's makeup. And I do agree. I mean, in Woodstock, they gutted out that whole community by making it all Airbnbs, And so the idea of protecting people that do have a vested interest and do live here and who are involved, I see the logic of that. But applying the same law to what is real, I don't get how this even is helping the college students because they're transient anyway. And so that landlords get to reset the market rent every year or two anyway. And the only reason a landlord would want to get rid of a college student that wants to stay is if they were doing one of the things that's a good cause. So I almost wonder if there's a way to just sort of carve out the college students here, the college rentals, like the designated college rentals. I'm not talking about college rental in a regular building, or either that or to break section 129.19 into sort of 2 different sections that have different rules that apply to the different classes. I know, Tim, you're concerned that that wouldn't be legal, but I don't know. We're kind of forging new ground here. You're proposing things that haven't been tested. I feel like it really fits the situation to treat the college rental market, housing market different than regular professionals and families in regular apartment buildings.
Yeah, I mean, I appreciate Adele's interpretation, but my understanding has been for some time that you can't market exclusively to students and you can't turn down someone who's not a student. Like you can market housing. And I don't know how we could write a law that memorializes a distinction that at best seems gray legally.
Yeah, I think and I think this might be and this is something I 100% I'm gonna follow up with Adele for some help with understanding in the future more so, because as far as I know, it was from the 2019 Tenant Protection Act that it was statewide source of income discrimination was expanded. But I think there still is some interpretation going on from Attorney General and also from different parts of the state that determine that. So always curious to read more, especially what our local real estate folks are getting information wise from that. That would be very helpful. But as far as this discussion goes, I want to keep us focused. Tim, I do want to point out, since you were allowing comments from the public, there is another hand up.
Oh, great. Who's that?
Robin.
Oh, I thought it was me.
Hi, everyone. Sorry
Valerie?
about that.
Robin, and then whoever was after
And
Robin.
then Val.
Great. Great. Can everyone see me? Hey, how's it going? Robin with For the Many. Just wanted to totally understand that there might be different situations that occur between college students and regular tenants. Obviously, college students are a more transient population, but college students still need these protections, right? Homelessness and housing insecurity is a huge issue for housing students. We speak with college students all the time that struggle with housing insecurity or get evicted from their apartments or face an unconscionable rent increase that forces them out of those apartments and force them to sometimes drop out of college or affects their lives in a lot of other ways. So while I totally understand that there is a different dynamic that exists with housing among college students, that doesn't mean that those college students shouldn't be afforded rental protections.
Val, you wanted to speak next?
Yes, thank you very much. I don't disagree with that. The tenants need protections against unconscionable non-renewals, but I'm not sure. Two things. I was reading the draft that was posted with the agenda, and I think one of the terms was I'd like to. We're all talking about the time notification. I'm going to stick with that. I had one other question, but I'm going to go stick with what we're talking about right now. A lot of the landlords start their rentals in June. I haven't heard anybody mention for those that start in August. And if your properties roll over in August, because a lot of people want the summer after school, after the school ends, they stay for summer, or they want to come just before school starts. Those students are looking for August rentals, and it's got to be at least a third of the population of the students that aren't starting in June, and they will not even be here when the window closes for looking for houses if it's 90 days and sometime within the summer that they have to respond to whether or not they're staying. The students who are that had the August rental from the year before will still be here, but we ask them to stay, that they don't have to give us notice until 45 days, somewhere in the middle of June or July, before we can start showing the houses for August. It makes there's nobody here to look at them. Everybody's gone home, or it's a crippling choice for those people who have an August rollover. I was hoping that could be addressed.
I'm not fully understanding because this law is not supposed to address each and every individual timeline. How does this August timeline not get addressed well?
Oops, sorry, I'm messing with
how
buttons.
is sorry, could you clarify a little bit?
Sure.
I'm
I'm sorry. I'm sorry I was unclear.
No,
If
it's
we-
all good.
I understand I have 90 days. The proposal that we're going to base the response time for the tenant to within up to 90 days before, anywhere between 30 days to 90 days before the lease termination. If a lease termination happens on August 15th, that tenant has until the beginning of June to say that they're not going to be coming. And then they're not, the new people that we would know, okay, the house is going to be empty. We have to look for tenants to fill these houses. There's nobody here. The tenants, the students, most of them have gone home. If they were on campus and now looking for their first homes off campus, so I'm generally renting to those new students from the houses that people have left, because I usually send out.
Okay, I get what you're
Right.
saying now.
Right.
Right.
So being able to say that I let you know, because right now I've already turned away over 100 people looking for housing for next year, because it's too soon to ask my current tenants if they want to stay. So I generally don't send that message out till after Thanksgiving. And then they have time, usually through the break, to respond, and then we can move forward. Whether they're at June or at August, everybody has time to get it done in the way they want. And in the past year, we've had our first difficulties with that. I think everybody just had a really hard year, and I want to judge going forward on what last year looked like for everybody. But
Last year was definitely, it was a tough year for everyone for
yeah.
sure.
and so I
So
wouldn't
what if we
want-
did something like 90 days prior to end of lease, like no less than 90 days prior? And then is when a tenant would have to respond if they're provided no less than 120 days notice. And again,
That's-
this is for the renewal, like just a little shift that way, and that would
Right.
give it
That's
a little
still
bit
the end of
of a
May.
month.
That's still the end of May. That's when students are in exams or doing graduation. They're
Because
they want to have
here-
all this
They
resolved
could have
before
decided
that.
before that though, because it's no less that,
Yeah,
no
that's what I'm saying. This is like the bare minimum, and this way it would be, this way it would work for different scenarios and stuff.
And if the tenant doesn't reply,
Well, they would have to do so like in that, like
If they don't, then they're.
no less
forfeiting
than
the
90
renewal.
days, you would still have
Before the
those
end of the
3
lease?
months. Yeah.
we're talking about the end of May then. The students have gone. If
Right.
your end of August start on the
Okay,
lease,
can we just, I want to go back to the point that we're not doing this only for students, like that
I
a
think
lot of
we're-
this, we're trying to keep people here who are long-term.
I understand that. And a lot of those long-term people make their living in the businesses that are supported by student money. And the students are an important part of the cycle, regardless of which end of the summer they start and end their rentals on.
Right,
And
but
they're-
we can't write the law just for students.
I understand that. I disagree with the idea of saying it doesn't cover students. I think it's illegal as well. I don't think they're not a protected class. So I think that we need to find a way to make sure it works for everybody as best as possible.
Yeah, Stana, I think it's really important, and Bravan brought up the idea that there's no question about it that students face housing challenges, but I think we do need to consider both the students who are currently housed as well as the students who are looking for housing. We're not
Or of course.
we're not just I think it is a law that has to be something that works for anyone who is renting. I mean, unfortunately, that's the challenge. It's not just for students, it's not for people who are not students, it's for all of the above. It's for people-
Agreed.
Can I speak?
And I think with guidelines like this, we need to be mindful of not creating new paradigms that make the housing experience, the finding housing, keeping housing. We're not trying to complicate that either.
Right, you don't want to have any unintended consequences. If someone wants to speak, just raise your hand so we can recognize you. I'm just concerned that if, I mean, do we feel like we have to put this in? Because I'm concerned that like there is no sweet spot.
That's why I didn't have it in the first draft, like, because I felt, I felt personally, just addressing what are the good causes, and what that all means was important. But what we heard in so many of the comments that were made, and it's awesome seeing, people really following through and attending this workshop meeting tonight, since making those first comments. Thank you for your involvement. Was that they want to see this bit addressed, in the in examples of wanting to offer the lease renewal, and creating like a timeline for that. So that's why we added it in. But yeah, the reason I didn't have it at first is because it's really hard, because if we go the route where we attach the tenant's response to when the notice of renewal is provided, that can be tough too, because I don't want to take away the right of a landlord like Val, for example, who does it, Thanksgiving beforehand, to continue that process. But it sure would be hard to make that possible, while writing it, if we did attach it, right? Because not every scenario would that be appropriate. If you catch what I'm saying. So that's where sticking it in relation to the termination, making it like the bare minimum, like common denominator, last ditch requirements, so everyone knows like they have to get a response from their tenant, basically. That was the goal here,
Okay.
But
I think we should just
if we
take
do it in a
care of
way that makes it so it's connected to when they get the offer, that gets weird, because there are so many different scenarios just based on having lived here for 20 years.
So I guess I want to hear from Tim and you and
Yeah.
Michelle, see where you're at now with it and try to like.
Yeah, what are you all thinking?
You want to chime in, Michelle? Your turn.
I guess, I mean, I think we need there just to be a fair enough amount of time for everybody. And I mean, I don't know what the answer is. It feels, if a landlord is going to give no less or 90 days, then I guess I want to understand why it wouldn't be okay to attach it to that. Because sort of to Matt's point earlier, is our goal is to retain residents. So, or one of the goals, obviously. So how to attach it to that allows a resident to plan. And I hear the issue with students too, but it's like, we sort of have to figure out where's the middle ground.
To attach it to when, sorry to clarify, to attach it to when they're given the offer to renew?
Yeah, so if the landlord gives the 90 days and then they have 45 days from that day to make a decision, I don't just threw that number out there.
So
Right,
the
but some people are
issue
doing it 5 months in
here,
advance, so.
yeah, the issue is 5 months in advance. Like I understand the reason for a landlord to want to do that, but that doesn't really help in every tenant scenario, because you don't know 5 months in advance if you're still going to be attending school here, et cetera, et cetera. Like that's too far in advance. And it doesn't seem fair to potentially be tying people to being forced to only have a chance to renew their lease if they stick to these very unreasonable timelines. And I understand the reasons for those timelines for sure. I get it, with certain markets, it makes sense, but it doesn't work in terms of protecting tenants and giving them the opportunity to renew,
I guess I can think about
the college is doing the same thing. The college is saying, we need to know whether you're going to take a dorm room before Christmas.
And I'm also
You can compare us to the college, though.
tenants.
Because they're a large landlord, they're not us.
Right, but if we're talking about covering everybody and the people that are not students, then it's going to be very different for them.
That's sort of what I'm saying is that, what if we look at like single parents or, people who want to stay in this community, giving them that buffer allows them to stay in the community and gives them more housing security, which is one of the things we want to supply. So, I feel like that's a huge issue and a huge thing that a lot of the participants who have been speaking out in favor of good cause, that's one of the big things to help them in that scenario. So a landlord giving a notice with great advance and then them allowing to say, yes, I want to continue to stay, it gives them housing security. So that's where my brain's going, fearing.
So Michelle, do you have an idea of the timeline that you think is reasonable?
I would be open to something like, if it is the 90 days from the landlord, to attach it then to that instead of the termination of the lease. So a person can potentially be like, oh, good, I know I don't even have to worry about my lease is up in December and it's June and my landlord already wants me to stay. So I'm good and I feel secure and know I'm housed for the end of my lease and for the next year.
So how about the tenant's acceptance or refusal must be provided in writing no more than 90 calendar days from confirmable written notice regarding their opportunity to renew the lease.
I think that's too long. I think it should be 30 days or 45 days.
Who is speaking? Nobody's been.
That's bad again. I'm sorry to jump in, but that's
Yeah,
like
you gotta
such a
raise
long
your hand
breath.
and let us recognize you, because it's not fair for everybody to not be treated the same.
So before people start hopping in, just for me to share with my fellow board members, where I would think, if we want to connect it to when that notice, of the opportunity to renew is provided, and we want to keep in mind there are some that do it 7 months in advance, 5 months in advance, 4 months in advance, etc. I suggest no more than 90 calendar days, because that's enough time to go and figure out what am I doing next year, and like that, and like,
So
who am I going to live with? What's my scenario? Just based on, because there were a couple of scenarios in the past year or so with folks, who felt they were strong armed into lease renewals, well in advance, 6-7 months in advance, and just help watching them kind of scramble to piece together their life, like totally having nothing to do with COVID, like straight up, like just, the facts of, am I graduating, am I not, like, am I going to have, this work study position or not? Like, let me go to my registrar, let me go to my boss, let me talk to my family, let me talk to my roommates and stuff. It doesn't, 30 days, if you're asked to do this 7 months in advance, 30 days is not enough. If you're asked to do this 90 days in advance, then yeah, 30 days is more than enough time. See how that frame changes. And so if we make it so it's connected to when that notice is provided, and if that seems to be what would be most fair for like the plethora of scenarios, we need to give the 90 days as, the like no more than 90 calendar days, because if we're talking 7 months in advance, that's how long it takes to figure out what my life looks like in 12 months.
So if we're talking about people who aren't students, let's say, do we think that 90 days is doable for them as well? Because let's say, again,
it would be tight.
That's what, you know what I mean? There's like, we're never going to be able to do this right for everybody. And that's why I don't really want to do this.
It'll be tight, but I would feel better if we want to put it like connected to when the notice is provided, like no more than 90 calendar days. If we want to do it connected to the termination of the lease, then like 45 or 60 days, go back to the original discussion point.
I'm back to not wanting to have this in there at all because I don't think that we can do it right for everybody. Lillian and Roger have had their hand up for quite a while. Can we recognize them?
So one of the scenarios that we could be looking at, which separates student housing from long-term housing, is hypothetically, I could have a house with 4 bedrooms and I have one student who graduates who says, I don't want to leave. I want to stay here for the rest of my life. I renew my lease. Well, I no longer have student housing because students aren't going to want to live there with an adult. So there's realities of student housing that are different than other housings. Students, when they're no longer a student, they don't belong in student housing because it changes the dynamic of who wants the house. Usually it's rented in groups. Other students don't want to live with them. We've occasionally let students who graduate maybe stay for 1 year, and that's the max. Because you have a desirability factor of who wants to live there, and students don't want to live with adults. That's not the nature of their culture. And I understand that you have a struggle here. How do you separate the rules out for one group of people versus another? But it really becomes a real conundrum in terms of how it's going to affect the majority size of the rental market. I mean, one of the solutions might be a way of legally separating them is maybe create some kind of licensing for student housing that puts them under a separate set of rules because it's licensed versus open housing. I don't know. I mean, I can't figure that out.
That's interesting to think about, Roger. You know, as a renter in the past, I have called places and have been told, sorry, this is student housing. We can't rent to you. So, and you know, I just don't know this answer. There is that parameter that something is student housing and the parameters are different? No.
It's illegal. That's
Okay.
illegal. I'm 50 years old. Like, what if I didn't want to live next to 40-year-olds? Like, it's just ridiculous. Like, you can't rent to people based on age or not rent to them based on age.
So confirming I was discriminated against when
Yes, you were.
Yeah. There's an attorney general page from Tish James's website for you on that one, Michelle. Anyway.
So I'm gonna propose that we strike this whole thing because there's no way to find the right sweet spot.
If I can make a comment, please.
Raise your hand or let us know who you are.
Yeah, Paul Knobloch. I've been
Paul,
listening.
Turn your camera on so we know who's speaking.
Oh, let me see. Oh, is it on? Am I there?
Perfect.
Yeah. I see the dilemma here, you know, that you guys keep talking about to separate the tenants and the students. But what if we find like a middle ground? I agree we should attach it to the notice, not to the end of the lease. You know, you guys are going to create like a scenario where 90 days before campus starts, there's going to be 1,000 landlords trying to fill hundreds of student rentals. Does that make any sense?
This is why we stay out of it.
You know, I think 90 days is fair for both parties, the tenants and the students. I think that's a middle ground. I would prefer 30, but I understand that the tenants, the regular tenants, need a little more time. So 90, I think, would fit for both parties.
Thank
What
you
if
for
my
that.
fellow board members think of that?
Sorry?
Like no
I don't know
more
what
than
Jake and Alex and Michelle think of that. I want.
like the no more than 90 calendar days from confirmable written notice regarding opportunity to renew lease. Like that's what I was kind of thinking was like a good middle ground, you know, if we want to connect it to the notice that's provided. you know,
Tim, where are you?
I didn't quite follow the logic of the comment, because I heard the gentleman mention something about 90 days out, there are going to be several individuals looking to rent places. And then he said he was comfortable with 90, but preferred 30. So I didn't follow how that worked.
I think what he was saying is how long they have to respond to the notice from the landlord.
yeah, the 90 calendar days.
90 calendar days from the
From confirmable written notice regarding the opportunity to renew the lease would be the response, acceptance or refusal from the tenant.
So then technically the landlords who like to get everything sorted and the tenants who like to get everything sorted and buy their holiday presents in advance, they could line everything up in September.
Sure.
So that landlord could
Yep.
contact their current tenants and say, are you staying? Yes or no? You have until
You have 90 days.
Christmas break, and then you have to tell me. And if I don't hear from you, I'm assuming you're not interested. And then they can market the property.
Yeah, like if you mull around like all the different scenarios, I think this might be the best like middle ground, you know.
I like that. And I feel like we also want to hope that there is always open communication. So if the tenant needs more time when that time frame is up, that tenant can say, hey, landlord, I need X amount of days. And then there's verbal communication that hopefully is always, encouraged. And then they could work together on that, where it wouldn't be like, they have to follow that to the T if they have verbal communication.
It could
What
be
do you think,
tenant's
Tim?
acceptance, refusal, or request for more time.
I kind of like that. What do you think, Tim?
I think we need Bill Murray to chime in. I know that he only recently joined the meeting, so can we put Bill on the spot?
Oh, thanks a lot.
Thanks, Bill. We're talking over 129-19 lease renewal procedure.
Yes. Let me start by saying I'm not going to ask questions that you probably have already answered. So I just have one question in this formulation is, don't we have in town month-to-month leases and week-by-week leases and that sort of thing? Are we just looking at year-to-year leases in this whole examination? Or should there be a separate table for month-to-month? I mean, I'm sorry, that's, in terms of 90 days, I think 90 days is sufficient. Thanks.
That's a good point, because I definitely remember at least one renter who shared that they had a month-to-month lease.
Yeah, I know people who are in that position as well. Again, this takes me back to why are we doing this piece? Take it out.
Yeah, month-to-month lease is interesting because there are protections to having longer leases, but there's flexibility to having a shorter lease, and both tenants and landlords, depending on who they are and their sensibilities, appreciate both. So, I mean, that's what I struggle with some aspects of this law. Like, are we trying to create guidelines for, different business models that, may be working just fine? Like there's no question we need to do more to protect tenants and make sure that people don't feel pushed out of their homes. But I don't know, I'm struggling with like how this piece works.
Yeah, I
Yeah.
won't take it out, honestly.
Honestly, that was another, like, for another historical perspective as to why I didn't have lease renewal procedure section originally in there, because like there's no way to address those shorter term lease scenarios in a way that would be fair. You know,
So then how would it work?
we're talking a completely different scenario there.
So some landlords would, if we don't have anything related to this section, some landlords would still do their thing like 11 months out, say, hey, do you want to renew or not? They could still do that. And then I think the other thing that we were trying to accomplish with these timelines is, you know, encouraging a communicative relationship between the tenant and the landlord too, because the landlord, it's helpful for them to know whether or not the tenant wants to stay or not, right? Like if the landlord is saying, you know, would you like to stay? And then they don't hear from the tenant, then they start marketing the property. Is that a big mess? Like, I think what we were trying to do was to figure out a way to create guidelines for all involved. So if we're removing this altogether, we're definitely not providing those guidelines. That potential for mess still exists.
Maggie's had her hand up for a while.
Oh, sorry, Maggie. Yeah, I saw
Sorry,
you.
Maggie.
Oh, well, that's okay. Thank you. I think that it is, I think that it's really, really important that you can, it sounds frustrating to try to reach some understanding of whether it should be notifying the tenant and the tenant having to respond. But I think that we cannot deny that this market in New Paltz, the idea that students need to work with the landlords earlier is just part of a reality. So I just want to encourage you not to throw out the baby with the bathwater. Do not throw out this section. Work it through. You've gotten some good feedback. I think you've gotten some ideas that you were kind of able to work through with giving landlords an opportunity to notify people, and having a timeline for them to respond. I don't know how else you can do it. What timelines you actually create is not the point at this, for me. It's that you please do that though. You know, please do make a timeline that people can know their landlord's going to talk to them about this, and the landlords can expect a response. It is chaos. I only have 2 rentals in the town, and you know, you put out a rental in August, you have 50, 70 people calling you. You don't want that. So you really do need to work with the landlords and understand and listen to what they're saying about what their working framework is for making leases. And you will be protecting students. That's all.
So Maggie, what language that you've heard so far did you like? When were we close? What did we say?
Yeah, I like the language of giving notice, having landlords be able to give notice 6 months or 8 months in advance, and having the tenants have to respond within 90 days of that.
Okay, so the idea is that the landlord can give notice whenever they want, and then the tenant has to respond within 90 days of that noticing.
Well, I'm not saying necessarily whenever the landlord wants to do this. You can identify how much time you'd like to be able to get the landlords to be able to do this. I'm just saying that make sure that whatever timeline you create, that landlords are able to give an opportunity for a renewal, that it be tied to a response within 90 days. So if you want to say the landlords can offer a renewal 120 6 months ahead of time, 8 months ahead of time, you can define that. if you feel that you want to be protecting people against not having to respond too early, right? That's
Right. I appreciate the idea that we're protecting the people who feel pressured to respond too early. But there are also both tenants and landlords who prefer to do their holiday shopping, you know, much earlier than anyone else. Like there
We're
are,
free to do that though.
there are, right. But if we say you cannot contact your tenant until 6 months beforehand, you know, what about all the tenants who want to know where they stand next year? Because, you know, they need to, you know, get that item off of their to-do list. They have several things on their to-do list, including figuring out where they're going to live next year. If they can sort that out right now and it's only October, it's one less thing that they have to worry about. Then they can focus on, you know, the rest of their responsibilities.
But then can a tenant advocate for themselves and say, hey, I want to renew for next year at any time?
There's nothing, that's not illegal.
Right.
Yeah.
I don't disagree with what you're saying either, Tim. I'm just sort of thinking of.
Well, the reason that does not work is because, so the tenant advocating for themselves is the prospective tenant who is in the dorms, who wants to tell the college that they don't want a dorm because they want to move off campus, and they can't go and find a place off campus because the off-campus housing, they're not allowed to start marketing it yet. I don't know, like, I mean, maybe that's fine. Or maybe we're sticking our nose in business transactions that the government should not be involved in. I don't know.
Well, I don't think we put a limit in any of these examples that we've thrown out here for the lease renewal procedure. We haven't put a limit on when that can happen. It's just that, you know, this notice has to be provided and a response has to happen within, you know, a timeline. And that's what we're trying to figure out. We're trying to figure out a way to do that that'll help provide a roadmap that will be useful without limiting, you know, those different examples of, you know, very early planners versus, you know, more typical timelines and so on.
And so we'll put something in just saying this doesn't apply to month leases.
It still would apply to month leases.
Yeah, I don't see how it wouldn't apply.
If you're month to month, you know, I feel like the way this is written, at a minimum, you have to give that tenant 90 days notice.
All right, should we hear from Valerie because she's had her hand up for a while? And please, if you're going to speak, remember to put your camera on if you have one.
Can you put our cameras on, please?
No.
We don't have the ability to do that.
Okay. This is
Thank
Daniel.
you very
I'd
much.
like to speak when I have
Valerie,
the
no, I will put your hand up then. I called on Valerie.
Hi, this is Valerie. I'm not in a place where there's private things, so I can't turn my camera on.
Okay, fine.
Thank you. I want to point, I think that we all want to prevent people from being non-renewed or some of the reasons given for why this law is being written are to prevent egregious evictions and not being able to give people the opportunity for non-justifiable reasons. For everybody wants, I would like my tenants to stay. It saves me a world of trouble to not, but occasionally I have those that I don't, and I'm not seeing where some of these timelines are going to protect that. But going back to what we're specifically talking about right now, I write leases in the summer. There's a thing that says that this is going to apply to sublets month to month, non-leased people. I write leases for two months over the summer, sublet for a lease for a month or two, that they're gone home for the summer and they don't want to stay. And this, the way it's written now, with the limitations on the days, the amount of time I have to give those people to make a decision to say our short-term lease that we both very much agree and understand what the time limit on it is, I have to like ask them if they want to stay a month before they ask to come. So how do we deal with that? I see that as an even bigger problem for the landlords that typically don't want to be locked into even 1 month leases or a couple of weeks, or the subletters for any kind of leases, to say that they fall under the same umbrella that these protections are meant to help, makes it almost impossible to write a shorter term lease when we're trying to write something that covers everything. I hope I was clear about that.
Yeah. Hey, Dan, and then Liz, let's have comments from you guys in that order.
Thanks so much. When I try and turn my video on, it says that it's in focus mode from the host, so I'm going to talk. Thank you very much. Thank you very much. I just want to remind everybody that I think the purpose of this law is to, as I'm hearing you folks kind of refine it over the meetings, is to protect tenants who want to stick around to be able to. And I think, so I do appreciate, 90 days notice to tenants, offering them a renewal is currently the most that the state law applies. So I think that's fine. I think the idea of giving written notice from the landlord, including language that lets the tenant know about the law and their rights, I think that's great, because I think a lot of the students would not otherwise. I think tying their response to the notice is great. I would reduce it to 45 days. I think for the very few people in town who are families renting, they know they want to stay. They would probably respond within 3 days. They have jobs, their kids are in schools. I don't see that is a problem for the families that are renting, if we have any that are actually renting in town. It's got to be that the vast majority of people who are renting in town are students. And I think giving them 45 days from notice, helps them focus and say, oh, am I, do I like this place? Am I a junior? I want to stay next year. Great. I have had many students sometimes say, I'd like a little more time. I always give them more time. But in terms of, 45 days from notice, I think that's very fair all around. This isn't the law trying to handle every single possibility. It's really trying to protect students or protect renters who want to stay, to have that ability to stay. So that would be my recommendation. Thanks very much.
Thanks. Just to respond to my board on that point, like the reason why 90 seem to be the make the most sense is because we're not talking, because in some scenarios we're talking like a lease renewal offered before Thanksgiving for the following year, and so that's where the 90 days is very different than 45 days or 30 days. It's 90 days of figuring out, like, am I graduating this semester or next semester? What is my home life looking like, next year? What can we actually afford? It's so different being asked to make that decision that many months in advance than 3 months in advance, right? So in order to come up with a compromise to best address all the different scenarios, that's where the 90 days makes the most sense. There's a couple of raised hands. I'll let the mayor do that.
And then Andy.
Hi. So yeah, I just wanted to echo a couple of other people and what they were saying about the 90 days. I think saying no less than 90 days allows kind of a lot of the spectrum to be able, of all the different people and all their different needs, landlords and tenants alike, to be able to communicate as long as it's ahead of 90 days, so people have plenty of time to plan within that 90 days after that. And landlords who want to start talking to their tenants 5 months in advance, and then giving the 45 days for the response makes more sense than bottlenecking so many students into kind of like a housing frenzy and like total chaos into, 45 days, which it sounds like that's not on the table anymore, which I'm really happy about. And also hitting at very difficult times in students' lives for planning during finals and maybe even when they're not in town. I also did think that Valerie's point was really important to pay attention to about when she is doing subletting or summer rentals for students who might not want to foot the bill for a full year lease. And to alleviate kind of that financial pressure, allowing someone to come in and sublet for 2 months in the summer, I don't see how that would fit within this picture.
Sorry, it was Andy's turn to speak.
Hi there. I'm a weekender. I have a home on Grove Street. Yeah, I think to the comment that was just said before, I'm not sure how this fits in with shorter than year-long leases. For example, we were looking at renting out the property to people if they wanted to come up for a month or two in the autumn. If I have to give them a renewal 90 days in advance, I don't see how that can possibly work. I'd have to give them a renewal before they would even be considering coming. And if there was no opportunity to not renew, then somebody could just move in for what would appear to be a month and then just turn it into an ongoing lease. So I'm not exactly sure how that could even work in this situation. And maybe that's the intent. Maybe the intent is to not have rentals like that within the village.
I don't think that is the intent. I think the only thing that the village law would try to prevent are folks who are not permanent residents offering short-term rentals. But if it's your permanent residence, you can offer a short-term rental. And also, in your example, you were talking about someone renting a place for 2 to 3 months. That would be considered a long-term rental. I think the definition is less than 30 days.
But with the short-term rental lots, you can't really do less than 30 days unless we're owner occupied at the time.
Yeah. Matt, did you want to speak?
Yeah, I just got one last thing to say. I mean, I think we've been batting around this particular clause for a while, and I see that there's a lot of complexity to it, and I see the different sides. What I like about all your strategies so far in this meeting is you've been stripping out things that are problematic in order to sort of boil this law down to the essence of what it is, which is basically to protect tenants from not being renewed unless there's a good cause, right? That's what we're doing. So I've heard from Stana, I've heard a little bit from Alex also that, she kind of added this thing in at people's request. I wonder if the best path forward is, again, to keep it as simple and clean as possible so we can all agree what is a fair cause for non-renewal and what is not, and protect people against non-renewal, and perhaps not have this whole notice complexity. I know, Tim, from talking to you, that you do want to codify it kind of and clarify it, and I get that and I agree with it, but I think there's just between month-to-month leases and the total difference of the college rental and the private rental market, and also the fact that, I think all of us should understand, right? I didn't know this until I got pulled into this whole thing on this law. Like the college rental market is like a well-oiled machine. The landlords know what they're doing. The students know what they're doing. Everybody knows how it works, and it's working really well. It's a big task to find housing for God knows how many students off campus, maybe what, 4,000 or 5,000 of them, maybe? I don't really know the number, but it seems dangerous to me to start throwing monkey wrenches into something that seems to be working well, especially since the whole issue of non-renewal doesn't even relate to the college tenants too much. I get what, I can't remember what the gentleman's name was. I get that there should be protections for these college kids too. I get it. And I agree with that too, but maybe stripping this out for now and just having it be, you have to offer a renewal unless there's a good reason, is a cleaner, straighter way to go. That's my final thought of the night. Thanks for giving me so much time to speak.
Thanks for sharing so many thoughts. Yeah, it's been so interesting actually, because it's like just so many of the original comments from the first public hearing, or maybe the second one more so, where there were actual comments made, really spoke to wanting, this particular process, but at the same time, like there's just no way to make this notification, like lease renewal procedure, work for every single scenario. It's absolutely like an interesting exercise going through this though. What are your thoughts now, Tim?
Yeah, I think listing the good causes is helpful. And, that's the way we, protect tenants and give them the right of first refusal. I guess we stay out of the business of providing guidelines in terms of when you tell someone whatever and when the tenant responds. Just stay out of that altogether. So the vast majority of the time, probably tenants and landlords are going to communicate with each other, and they're going to offer a renewal or not. I think what we were maybe trying to do is to try to, fix other and maybe, that's kind of what we started the evening off with, like, let's focus on the essence of this law and not try to do other stuff, because there are times where tenants and landlords are not communicating effectively. And were we trying to create guidelines for those situations using this law? And maybe we just opened a Pandora's box by trying to do that. And that's a different law that someone else can write. We cannot figure it out.
Well, that's kind of what I was thinking, could be even like another thing that like maybe the Landlord Tenant Relations Council could work on, which could be like not even a law, but like, like best practices for lease renewal, and like literally like take notes looking at this meeting and all the other public hearings on this law, because we've heard so many different inputs about like at least 180 different approaches, to leases in our little village, and come up with kind of like a supplementary handbook, that goes next to the handbook that they made, that is like, here's a billion different approaches, here's some best practices, and can do a lease renewal drafting workshop series with, legal services of the Hudson Valley or something like that, like really turn it more into like taking that approach, if it's something like that we can't legislate because there's no one size that could possibly fit all, or would we want it to?
I think that's a really good suggestion, and that seems like that could be something that the Landlord Tenant Relations Council could work on. Like, tenants and landlords could say, this is what works. Like when you're communicative in this way with this amount of lead time, and then you respond to whoever, asked for your feedback, you do it in this amount of time and no longer than that amount. I think that would be great. It kind of reminds me of, ideas that we've batted around in terms of like playing music during the day in the afternoons. Like to try to legislate that is a big mess and a Pandora's box, but maybe it would make sense to have suggested guidelines like, sometimes your neighbor needs to play music, and then sometimes when you play your music too loud, it's not great for your neighbor. And and I'm talking about during the daytime, like work with each other, be understanding, as opposed to trying to legislate away and turn this into the town of Footloose, where we don't allow dancing and we don't allow music on Saturday afternoons.
Yeah. And at the end of the day, what we wanted to see in this particular section, or what I heard people wanted to see, was, that there's just an expectation for communication. But I think leaving this out doesn't remove that expectation for communication at all.
Yeah. We, in the interest of time, it's 9 o'clock.
Right.
And I see somebody else has their hand raised, but I just wanted to mention the time because we said a stop time of 9. But I think it would be great for us to, moving forward, clean this up and with the things that we decided upon today. And then I think we wanted to set a public hearing for the next meeting, if I'm correct. And perhaps we even have another a session like this in the future, because I find this to be very helpful.
Agreed.
Well, I think, what do you guys want to do with this? Want to strike the lease renewal procedure section? And then I would say with that, I feel like we've addressed everything that's been a question that's come up, unless there's more.
We did agree to a hard stop at 9, so I don't know what we want to do.
Yeah, I think I can't say with positivity because I got to look at it all over again with fresh eyes with the changes. That's just my better way of working.
Yeah, I think I'd like to do the same, and not to repeat, but we did say we'd end at 9 p.m. So let's move on to our next meeting, discuss it a little bit there, and let's have another workshop meeting in 2 weeks.
I have one.
I don't want to say for sure that we're going to have another workshop. I want to see how it goes at the next meeting when we have the public hearing.
Yeah, let's set our public hearing for the 13th. I just made a copy of this with all the comments, shared it. It's labeled draft 3, and I'm going through and accepting the changes that have been made and discussed.
So do we need to set the public hearing?
Yeah.
So we're setting.
I'm sorry, I know, I hate to interrupt, but there are other sections. We only went through like 2 sections. I have a very important, something that's very important that we didn't address.
We just don't have time tonight, Adele.
But then you're gonna have a public hearing on it.
What section?
Section 129(18)G, where when an owner needs to sell their house.
I'm sorry, I'm gonna have to sign off. I'm sorry, Adele, I don't mean to be rude, and I do want to discuss.
I'm gonna have to as well.
But when we set this time, I was very clear I had to leave at 9 o'clock. I do want another workshop because
I appreciate that, and I really appreciate that. I was hoping that maybe before the public hearing, so you don't have to do a whole other version, that you have another workshop, because this was really helpful. But this is a very important section.
Let's not set a public hearing, and then we'll just talk about the draft that's in front of us next Wednesday.
Thank you.
Wait, why would we not set the public hearing?
Because we don't have it. We should only set public hearings when we have a final draft.
Okay.
So the board feels we don't have a final draft?
I don't feel we have a final draft.
I don't either.
Same here.
Okay, I think we're damn close, which is good.
We are getting
And I
close.
feel like the draft, we're being hyper transparent with, and we're showing this working draft in real time.
So what it would help me to know what the rest of the board, I know everyone has a hard stop, but like, I just don't know what else you all want to keep working on at this point.
Right now, for me, I personally need to look at everything that transpired today with fresh eyes. And to also, I do have notes on other things, and I'm not even going to start talking about it because of in the interest of time. But clear, mostly because when I do an edit of anything, I need to then put it to bed and then look at it again with fresh eyes, just to take it in. That's just my process. I mean, this is too important to miss something.
Yeah, and I don't think we slow down anything by not calling for a public hearing at our next meeting, because ideally anyone who's following along will comment on this working draft, whether it's in the formal public hearing portion of a meeting or just in public comment. So it's all headed in the right direction.
I move we adjourn.
Second. All in favor?
Aye.
Aye.
Thank you, everyone. We'll continue this discussion.
Hey, Tim, when would the workshop be?
Well, we have a regularly scheduled meeting. Wait, what's the date of next?
So the next regular meeting is the 13th. The
Oh,
6th,
not
because the
next-
1st of October, the first Wednesday in October is the 6th. So it's the 13th and the 27th are our actual scheduled meetings.
So let's do a workshop next week, dude.
I will not be able to clerk it next week. I am off. So if you guys want to schedule it for next week, you have to figure out who will be the clerk. And I could talk to Nicole or Alana about that.
Whatever you want, Tim. I think that this was by far the most productive format that I've seen yet. I feel like it was actually, actually made some good progress. And I feel like it was it felt collaborative somewhat. Don't you agree?
Yeah, I think the workshops help as opposed to a regularly scheduled meeting where you have a bunch of other stuff to do and then your brain ends up feeling a little too mushy.
And then also, if it's a public hearing, people get on their soapboxes and it really doesn't help bring it to I know it has its role and it has to go through that legally, but I think another workshop before finalizing a draft and having a public hearing, which is really the point of that, is to give it a thumbs up or a thumbs down, more or less. Right?
I can ask the board if we want to do another workshop next Wednesday.
It's totally up to you, or we could wait longer. I don't care. But I think that this is
May I interrupt for a second?
sure.
This is Valerie. Tim, while you're still on, and I didn't have the opportunity to thank the other board members, but thank you very much. I really appreciate this opportunity for everybody to talk together like this. Sorry to interrupt. Thank you. I'm going to sign off.
Yeah.
Have a good night, everyone.
I just want to
echo that.
And so everyone's aware, the meeting's over. This is the equivalent of us standing in the parking lot outside after the meeting.
That's definitely
Okay.
true. Yeah.
That's okay.
Yeah. All right.
I can talk to the board and see if we could agree to set